Okay, Committee on Judiciary and Hawaiian Affairs is called to order. It's Thursday, February 4th, 2 o'clock at conference room 325. First item on the agenda today is House Bill 740 related to voting. And first testifier, Scott Nago, Office of Elections.
The office stands on its written testimony in support and will be happy to answer any questions. Thank you.
Thank you, Mr. Nago. Um, Also have testimony from Ed Sniffen, Department of Transportation.
Yeah, Ed couldn't make it. This is Preston Cole with Department of Transportation. We stand by our testimony as well.
Okay, thank you very much. Next we have Janet Mason, League of Women Voters. Okay.
The league stands on our testimony in strong support.
Okay, thank you very much. Next, Hawaii Health and Harm Reduction Center, Nikos Laverners. She's not on. Sandy Ma, Common Cause.
Good afternoon, Chair, Vice Chair, and members of the committee. Sandy Ma for Common Cause. We strongly support House Bill 740 for automatic voter registration. Automatic voter registration means that when a person interacts with the Department of Motor Vehicles to get a new driver's license or state ID, or for updating a driver's license or a state ID, and a person does not opt out of registering to vote, the information is automatically transmitted to the county elections office. And so this will benefit the people of Hawaii to not have to additionally register to vote separately or to complete additional information to register to vote. This will operate to secure our elections by updating our voter rolls. This will save the state money by duplicating and automating services. And this will update and benefit vote by mail by ensuring that our ballots are sent to the correct addresses. And finally, this will benefit democracy by ensuring access to the people to register to vote. We also submitted testimony on behalf of AVR Hawaii Coalition, also in support of HB 740. The AVR Hawaii Coalition is an organization, is a group of several different organizations from unions such as HGEA, women's groups such as AAUW, and organizations that support at-risk groups such as Hawaii Appleseed. We recognize, AVR Hawaii Coalition recognizes the importance of automatic voter registration. Over 20 states and the District of Columbia have adopted AVR. So we thank you for hearing this bill and we urge you to move it out of committee. Thank you.
Thank you very much. Okay, we also have received numerous individuals and organizations all in support of the bill. Members, any questions? Representative Ward.
Sure, just a point for clarification, if you will. When you do the driver's license, does that automatically register you? Or in this one testimony by Mr. Nago, he said you have to fill out the voter registration. Is it one or both?
The process outlined in the bill is that the
automatic, right?
the person registers for their driver's license.
And if you don't opt out, you
and,
got
and
voter.
if you don't opt out, it's
Yeah.
automatically transmitted to the Office of Elections.
Mr. Nagua's testimony made it a little bit different, but my other question, more technically, is when you sign up for a driver's license, you don't need to be a citizen, right? Or do you? Because to vote, I think you have to be a citizen. So,
Vote, you have to be a citizen.
but if you got your driver's license, you automatically get to vote, but you don't have a citizen check mark. Are we skipping that? Is the question. It's a technical one. Does anyone on the line know that, Miss Ma, or anyone?
Yeah, hi, this is Preston Cole with the DOT.
Transportation.
Oh, yes, DOT, you'll know that.
Yeah, currently the application already transmits, captures the voter registration information, the current application for a driver's license. The participant or the applicant for a driver's license could be one that is not a U.S. citizen as well. And in the bill, I believe it addresses it. It does address an affidavit of some sort that needs to be filled out if someone who does not present legal presence documents still wishes to register to vote. So there are some provisions in the bill to address the non-U.S. citizen.
Do you have the line and number?
Let me.
Because I was looking for that as I cursorily went through it, but I didn't see it. Because it looks, the easiest way is to make it automatic, but the citizenship could be a bit of a tripping up.
Yeah, let's see. If you go to
Page 3.
page 3, number 4, or line number 5, on page 3, it starts to there's the discussion on the affidavit about someone who does not present documentation that proves citizenship. I think it's also in another place as well. I saw it in 2 places.
Document that demonstrates lack of U.S. citizenship.
Yes, because for real ID, again, you need to prove citizenship. So there's 2 types of driver's license, a real ID and a limited purpose driver's license. So limited purpose, you do not need to prove legal presence in the United States. And that's a choice. Some people, they are citizens, they choose not to present documents. They don't want to look for it or they can't find it, and they'll get a limited purpose driver's license. And some are truly non-U.S. citizens.
So current,
Ms. Ma?
thank you so much, Representative Ward. So currently the system, when you register to vote at the DMV, you complete an application form. And along with the application form, there is an affidavit in there where you attest that you are 18 years of age, you are a resident of the state of Hawaii, and you are a citizen. And so that information will also be included in the automatic voter registration process, where there will be a drop-down menu, and that information will be included in it, and where you will attest also that you are 18 years of age, that you are a U.S. citizen, and that you are a resident of the state of Hawaii, and that you do not opt out of the voter registration process.
That was very helpful. Thank you. Thank you, Chair.
Okay, thank you. Members, any other questions? Seeing none, we move on to House Bill 73 relating to emergency workers. And then first up is the Department of Health. Okay, well, Department of Health in support. Office of Public Defender, State of Hawaii.
Good afternoon, Chair Nakashima, Vice Chair Matayoshi, and members of the committee. My name is Jackie Esser. I'm here with the Office of the Public Defender. We're in opposition of this bill. We'll rest on our written testimony, and I'm just here to answer any questions if necessary.
Thank you very much. Next, Aaron Farias, Honolulu Police Department.
Good afternoon, Chair and Committee. This is Acting Major Aaron Farias from the Honolulu Police Department. I will stand by our written testimony in support of this bill. Thank you.
Thank you very much. In addition to those who have already spoken, we have several agencies and individuals who have also presented testimony and support. Members, any questions? Representative Ward.
Thank you. I don't have the testimony of the persons who said they were in opposition of it. So could they explain what their opposition was?
Okay.
Or the person?
Hi, Representative Ward. I'm with the Office of the Public Defender. We did submit written testimony in opposition. Essentially, we believe that all employees should feel safe as they go about performing their job and duties. And we keep carving out special provisions for classes of people, which elevates what would be a misdemeanor offense to a Class B felony offense, not based on the person's action, but on the status of the victim. So we have cautioned the legislator over the years about opening the floodgates, and every year we see that we're trying to expand the definition of an emergency worker. 911 operators, they are critical workers, and we appreciate their work so much, but however, they're not on the ground during an emergency. They're dealing with people in crisis. Their lives, they're away. I'm in a call room, protected. And so our office does not see, as far as protecting the health, that this bill does anything. Also, by enhancing sentencing from what would be a misdemeanor to a felony conviction, a Class B, punishable up to 10 years in prison, we are not treating, one, we're gonna see the impacts on our criminal legal system, more jury trials, and then you're dealing with overcrowding in our jails and prisons, and the collateral consequences that go along with a felony conviction, which impacts not only the individual for their life, but their family. And so based on those reasons, we're in opposition of adding, expanding the provision of 707-700 to include 911 operators.
Okay, thank you.
Thank you, Chair.
Any other questions, members? Representative McKelvey.
Thank you, Chair. For Public Defender's Office, they're still on. So if I'm gonna follow you correctly, I mean, because it's a status-based, penalty system, it wouldn't apply to whether they're in any zone of danger or not. So like they could be at Foodland or any shopping mart and get assaulted or mugged, unfortunately, and that person would then possibly face the enhanced penalties of a felony because that person is an emergency worker, even though they're not performing those zone of danger duties.
No, it's in the performance of their duties as an emergency worker.
Okay. Representative Nakamura.
So following up on Rep. McKelvey's question then, since these emergency workers are in isolated rooms, they are not confronting individuals on the front line, on the streets. Why would this concern be raised? The purpose of this bill is not to give them additional protection under this section that you mentioned, it is to raise the status and acknowledge the level of work that our 911 workers are doing. And this is a first step in the process of elevating their work from being, by being identified as clerical. It's nothing to do with what you are, it's not to give them any special protection. And because they're in isolated areas, it's almost irrelevant. Are you seeing this differently? This is for the public defender.
Oh, am I seeing it different? So it includes their duty as an emergency worker defined under section 707-700. So it adds them to that definition. So what it does is it takes an assault, if they were to be assaulted in their line of, in their work duties, if it was a normal misdemeanor offense. So a misdemeanor assault is when you cause pain to someone. Okay, so you cause pain to this 911 operator, assuming that's even possible. I don't know if—
I'm wondering your concern, if they're in an isolated room, who's gonna assault them?
I mean, exactly. There's no point to this bill that I know of. I've never seen a case that this has happened. But even assuming it does happen, we just really caution the legislator to go forward with enhancing sentences, because that's not making our community safer. It also, we want to feel, our community members need to feel safe when they're calling 911. And when you're, there's a threat, a possibility of a 10-year prison sentence if something happens while you're in crisis, that's just not building relationship and rapport and working with community and the 911 operators. Absolutely, we should be, elevating our 911. We're very grateful for them, but enhancing a penalty is not the way to do that.
Okay, well, I guess because they're in isolated rooms with very high security, typically at civil defense level security, I really have some concerns about that, just the concern you're raising. Thank you.
If I could ask a question, Chair.
Representative Matayoshi.
Thank you. I just want to clarify. I believe the purpose of this bill was to elevate the status of 911 operators to emergency workers to provide other types of protections for them, give them access to mental health treatment and other things. It seems like both Representative Nakamura and the Public Defender's Office are in agreement that as far as physical harm goes, there's very, very, very little chance of that happening. So the elevated penalties for assaulting an emergency worker are rather moot here. If that's the case, then I would think that the Public Defender's Office would have no problem with that aspect of it, since it's moot, and would be fine with 911 operators getting the elevated levels of mental health protection and other perhaps pay protection that are warranted. So if, I guess for the Public Defender's Office, if you agree then that there is basically little to no possibility of this elevated penalty being applied for the assault portion of it, then I'm assuming you don't have any problem with the other aspects of this, of elevating them to an emergency worker. That's the real purpose of this bill.
I mean, again, all employees should be safe and paid well and given mental health services. A public defender, prosecutors are protected. Public defenders aren't. I don't know of any prosecutor who's been assaulted in the line of duty. I do know public defenders. And it's just where does the floodgate end is our concern. So I do agree that they should be given those services and elevated if that's what makes it happen. However, with the enhanced sentencing, our office is very concerned about that, and we'd ask that the legislator look at ways of enhancing the penalty then. Thank you.
Okay, thank you. And maybe you can talk to Rep. Nakamura about including you guys next year.
That's what I'm saying. You should make an amendment, Chair.
Chair.
Representative Ward.
Just a footnote to Representative Matayoshi. It's also, as the fire department indicates, they will be compensated better if they are so categorized. So, I mean, that's an important thing. And to my way of thinking is, emergency service is for those when you got a crisis, they got to go to work. They can't do something else. So in a way, contrary to the prosecutor, I mean, it's to protect people from getting harmed by getting those people to get the communications out to save people's lives, not to fear a felony because somebody's going to break into an isolated room and hurt
Yeah,
them.
Representative Ward,
Thank you, Chair. That's all I wanted to say.
comments are for after decision making. Questions now. Any other questions, members? Seeing none, we'll move on. House Bill 652 related to exemptions from jury duty. And first up, Mark Sanoki, Judiciary, State of Hawaii. Oh, I'm sorry. He's not present. Actually, there are one comment and 4 supports, and none of them are going to be here. So I guess we will move on to House Bill 340. Proposing an amendment to the Constitution of the State of Hawaii to require the Judicial Selection Commission to be guided by principles of merit in the selection of judicial nominees and the retention of judges and justices. First up, we have from the Judiciary, Ron Miley.
Good afternoon, Chair Nakashima, Vice Chair Matayoshi, members of the committee. First of all, I'd like to apologize. On the submission of our testimony, it was indicated that we were in opposition. The judiciary is not in opposition. We submitted testimony with comments, and at this time we would stand on our testimony with comments, and I'll be available for any questions. Thank you, Chair.
I believe they did correct the information on our testimony, and it is listed as comments, Mr. Miley.
Okay, thank you, Chair.
Okay, next we have Ronette Kawakami, Judicial Selection Commission.
Aloha mai kako. Good afternoon, Chair Nakashima and Vice Chair Matayoshi. I'm Ronette Kawakami with the Judicial Selection Commission. We would like to stand on our written testimony, and we are available for, or I am available for any questions. Thank you.
Okay, thank you very much. Next we have David M. Louie.
Good afternoon, Chair Nakashima, Vice Chair Matayoshi, and members. Thank you for the opportunity to testify. I testify on behalf of myself and the members of an ad hoc steering committee that was put together that are in strong support of this constitutional amendment. And let me briefly state why. You have a report submitted along with my letter, which was prepared by our committee. Our committee consists of 4 present and past attorneys general, myself, Claire Connors, Doug Chin, Marjorie Bronster, former chair of the Judicial Selection Commission, Susan Ichinose, retired ICA Judge Dan Foley, John Komeiji, a noted attorney, and the speaker, Scott Psyche. This ad hoc committee was convened in October 2020 to take a look at the Judicial Selection Commission and to see if methods could be proposed for improvement of the judicial selection process. This is a very important process for the selection and retention of judges in the state, all the way from the Supreme Court justices down to district court judges. As we looked into this, we had a process. We met with many stakeholders, that CJ, the judiciary, retired justices, the Hawaii State Bar Association, American Judicature Association, Hawaii Women Lawyers, and the Judicial Selection Commission itself and some of its past members to talk about this process. I should note, nobody is in favor of elected judges. We believe the Judicial Selection Commission process has worked well, but it can always be improved. And as we looked at this, it turned out that there is nothing in the Constitution or in the rules of the Judicial Selection Commission that provide for merit standards and merit principles and to be governed by merit principles. And we think that that is an important omission that should be corrected and should be changed by a constitutional amendment. And so we have proposed through Speaker Saiki this constitutional amendment, and we stand in strong support of it. The reason for this is to make it clear and to underscore to both the members of the Judicial Selection Commission and to the members of the public whose confidence is needed for the whole process to work, that the selection of judges would be based upon merit principles. Another recommendation that is being made by this ad hoc committee is through a resolution, and it's noted in the report. This is a report that summarizes all of the things that the committee did and the recommendations, and the additional accompanying recommendation is for a resolution so that the judiciary, working along with the Judicial Selection Commission and others, would develop standards, clear written standards, because right now there are no clear written standards for what the Judicial Selection Commission does or how it does it. And we believe that that's an omission that should be remedied. I don't know how anybody could say standards are bad, but maybe there will be some. We just think it's important and that the judiciary should work on that and establish training so that this very important process for the public, for our government, for the people of Hawaii is followed through and made better. With that, I think it will benefit the state, benefit the public, and benefit the judiciary. And I thank you for the opportunity to testify. I'll be happy to take any questions if there are any.
And thank you very much. Yeah, that's all the testifiers we have signed up. For our members, are there any questions? Representative Ward.
Mr. Louie, thank you for serving as our former Attorney General. We should know what judges and merits all about. Let me read this from the man on the street. When it says, should the state of Hawaii require the Judicial Selection Commission to be guided by principles of merit in the selection of judicial nominees, you mean you guys aren't doing that now? It makes us look like we got flunkies and guys without any qualifications. However, the present testimony from the selection committee by Ronit Kawakami says Rule 10 states, the commission shall consider each applicant and petitioner's background, professional skills, and character and give consideration to following qualification. So if it ain't broke, or is it broke? Maybe that should be the question. Are we getting people who don't have merit on this system? And why are we bringing attention to it if we do? Because the way the wording is, looks like we don't have qualified people and they're all political hacks. That was a question.
Thank you, Representative Ward. Let me note that the members of this committee believe that the Judicial Selection Commission has worked in the past, but that it can always be improved. Recently, there were recent selections made, nominations made on the list to the appointing authority by the Judicial Selection Commission for the position of a Supreme Court justice. There were 4 names that were selected. There were a total of 6 who could have been selected, but only 4 were selected by the Judicial Selection Commission. And I happen to know personally that there were 2 sitting Intermediate Court of Appeals justices who were not on that list, as we discussed this, as I discussed this with people and other people on this committee discussed it with other people, including justices, judges, attorneys, and other members, they were shocked at what had happened. and there were questions raised about this. So that was the impetus for this. Is the process broken, Representative Ward? I don't believe the process is broken. Can the process be improved? I think the process can be improved. Right now, there is no statement in the Constitution that says that the Judicial Selection Commission shall operate based upon merit principles. If the Judicial Selection Commission believes that they are operating on merit principles, then I don't think they will have any problem, or they should not have any problem in agreeing that, well, let's just underscore that and make that clear to the public and to the members of the Judicial Selection Commission, that merit principles should guide the selection, and so that there is not a potential problem of people either bringing politics back into the system, which occurred before the Judicial Selection Commission, or people trying to make the choice for the appointing authority. The object of the Judicial Selection Commission, in my view, and the members of our committee, is to give the appointing authority, whether it's the governor for circuit court judges and appellate judges, or the Chief Justice for district court judges, the widest possible selection opportunity to pick the most qualified people. That's who we want. We want the best and brightest. And so we believe that, and I believe that this process can be improved. I don't believe it is an indictment of the system to say that we want to underscore and we want to make sure that merit principles are followed, and that there is training, and that there's a whole process, protocols and things like that to ensure that merit principles are followed in this selection and retention process.
Thank you, Mr. Louis. Without saying it, you're saying that we've got some people who are not qualified compared to others who didn't get on. But I hear what you're saying, but it sounds a bit odd.
May I comment, Representative Ward? We are not saying that there are any unqualified people who have been selected. We are not making this about a selection of any particular person. We are talking about the process and improving the process.
Representative Nakamura.
Thank you, Chair. I also have a question for Mr. Louis. My question is, rather than a constitutional amendment, what if your committee works with the judiciary to develop clear and measurable evaluation standards? Because no matter what, even with a constitutional amendment, that's what your report is saying you need. And it should be in writing and be a little more formalized. Why not just go there with the judiciary?
Thank you for the question, Representative Nakamura. It's a very cogent question. That sounds good on its face, but the problem with that, and the reason why a constitutional amendment has been proposed, is because the Judicial Selection Commission, and the authority for it to act comes from the Constitution and from the Constitution alone. And the Constitution says that the Judicial Selection Commission will promulgate its own rules, and that those rules will have the force and effect of law. In other words, you representatives in the legislature cannot affect their rules. If you think they're doing something wrong, you have no power to do anything. In some ways, that's a good thing, because you want to insulate the Judicial Selection Commission from political influences and things like that. In other ways, it raises the question of who will guard the guardians. If the Judicial Selection Commission is able to establish their own rules, and those rules have the force and effect of law, then they are a law unto themselves. And because there is no clear exposition in the Constitution of what they are supposed to do and what principles they are supposed to adhere to, I believe that that is an omission, which is why I think a constitutional amendment is needed. Once you establish the principle of merit selection, of merit principles, being followed by the Judicial Selection Commission. The judiciary can work with the Judicial Selection Commission. I'm sure the people on our committee would be happy to have input in that and develop training, protocol, standards, and things like that. But it's necessary to have it in the Constitution.
I have a question also for Ronette Kawakami when after others have had it.
Members, any other questions? Representative McKelvey.
Thank you again for Mr. Louie. Hey, David, real quickly. So rather than adopting a new amendment to the Constitution, why don't we amend the existing one to put limitations to strike a more fair balance, but to strike a balance nonetheless on the Judicial Selection Committee? Rather than canceling or trying to amend, effect, if you will, through another amendment, why not just propose to a people in a change to the existing constitutional amendment to provide that type of at least somewhat oversight, but yet without creating a political inference system?
Thank you, Representative McKelvey. It's a pleasure to see you and talk to you. I believe that the process is necessary in order to, the Constitution stands as it is. Right now, the Constitution and any prior amendments constitute the Constitution. In order to change that in any way, shape, or form, you have to go through a constitutional amendment process. So that's why we believe that that's necessary.
No, I don't understand why you're not trying to address the existing amendment to a Con-Am instead of adding a new one. See what I'm saying? It's more generalized. I hope it passes. You do know most of these things fail because blank means no's. So but I just wanted to ask you that question. Thank you, Chair.
Thank you. Members, any other questions? Representative Ward, second time.
Yes, Mr. Louie, thank you again for your service as as the Attorney General. And you are a good wordsmither. Isn't there a better way to word this thing than the way I read it? It's an embarrassment to the judiciary branch, the way that it reads. Can you work out some better language than the way it says? Because it implies things that I think the guy in the street's not going to like very much, and it's not going to make us look proud. So I just maybe make that a suggestion. If there's better wording, I may go for it. But the way the wording is now, quite frankly, it's an embarrassment to all of us. Thank you.
Thank you, Representative Ward. Just to respond, I'm always happy to take direction from this committee in what it is interested in doing, and be happy to do that. I hesitate to try and propose anything in a vacuum. We believe that this language, which was the matter of a degree of debate and just to try and get it right, was to try and underscore that merit principles are the standard and what we should adhere to at the Judicial Selection Commission level. You don't want to make it too complicated. You don't want to necessarily go into particular standards. After all, this is the Constitution. I believe that this language does it, and I don't believe that this language takes a swipe at the judiciary. That is certainly not the intent of anybody on this committee or myself. We have the greatest respect for the Judicial Selection Commission and the judiciary. And so this language was selected to do what I thought was fairly innocuous, which is, how can standards be bad? Let's have some. Let's have some.
Members, any other questions? Representative Nakamura.
Just a question for Jeanette Kawakami. Oh, Ronette, thank you. My question is, given the concerns that are being raised by this ad hoc committee, and knowing that your commission has the opportunity to establish your rules and procedures and standards, would you be willing to expand on your 7 criteria to provide more clear and measurable evaluation standards?
We're always open to improving the processes of the Judicial Selection Commission. Nobody's against that. As written, the request for to include this merit, idea of merit, I think is, I guess from our point of view, our rules already talk about merit.
Mhm.
And from a practice standpoint, all of our commissioners walk into the room looking at merit. That's a given. So it's a little bit mystifying as to why they're focusing on merit. We're happy to work with this ad hoc committee. I testified in front of them. I answered their questions to the best of my ability. A lot of what the Judicial Selection Commission does has to be kept confidential as a part of the process. I'm sure all of you know why the Judicial Selection Judicial Selection Commission came into existence. The idea was to have merit selection. That's what it's called. And across the country, what we hear is Hawaii has the best way of choosing judges because we're not elected, and politics has been gleaned or pulled out of the process. And that's the point. 5 of the commissioners are lay people, and that is a mandatory matter. That is by constitution. So 5 are people from the community. These are, I'm sorry, Representative, you have a question. I'm sorry.
Yeah, my question is that, you know, it seems clear that you have 7 criteria. I think what they're asking for are more clear and measurable ways to evaluate that criteria and to put that in writing. And that's the part that, is that, are you willing to go there, is my question.
We'll be happy to discuss it and look at it.
Yeah.
I mean, I think that that's a perfectly reasonable request from anyone.
It seems like that, from what I'm hearing, is where people want to go, but by working together, maybe you can do that. So just my observation just from listening today. Thank you.
Thank you.
Thank you. Members, any other questions? Seeing none, we will move on to House Bill 631 related to financial hardship. And we have Jacqueline Easer, Office of the Public Defender.
And good afternoon again, Chair Nakashima, Vice Chair Matayoshi, and members of the committee. The Office of the Public Defender strongly supports House Bill 631. I'll rest on our written testimony, and I'm here to answer any questions if necessary.
Okay, thank you very much. Next, we have Mark Santoki, Judiciary. Oh, I'm sorry, not present. Kendrick Farm, an individual. Not present. Okay, and then that's all of the testifiers we have listed. There are several individuals and organizations who have provided testimony and support. Members, are there any questions? Seeing none, we will move forward. House Bill 783 relating to the Uniform Probate Code. Members on this, we have five individuals signed up, one organization, all in opposition, but no one will be here. So I guess there's no one to question.
Question the chair.
House Bill 347 relate to judicial enforcement of the Uniform Information Practices Act. Cheryl Kakazu Park, Office of
Noon,
Information
Chair
Practice.
and members of the committee. I'm Cheryl Kakazi Park, Director of the Office of Information Practices. We provided detailed written testimony explaining the important differences between the de novo and palpably erroneous standards of review and how this bill could have unintended consequences that could threaten the advantage that the public currently has when OIP opinions are reviewed under the palpably erroneous standard of review. So while this bill does not currently change OIP's standards of review, it wrongly applies the palpably erroneous standard of review under a new procedure affecting appeals from circuit court decisions. Unlike OIP, the circuit courts have no special expertise in administering the UIPA on a daily basis, and thus circuit court decisions have not been entitled to a presumption of validity afforded under the palpably erroneous standard of review. The more appropriate standard by which appellate courts should review circuit court decisions is de novo review, as there is no need for the ICA or Supreme Court to defer to the lower court's decisions in these cases. OIP fears that an unintended consequence of this bill will be that the appellate courts will find this palpably erroneous standard of review to be inappropriate for reviewing circuit court decisions and will water it down over time, so that when that standard is later applied in reviewing OIP decisions, it will not be as strong as it is now. While it would not immediately affect OIP, a watering down of the palpably erroneous standard over time will eventually give agencies a better chance of winning on appeal when they challenge OIP decisions. Please don't ask me about the AG's proposed amendment because I just saw it a few minutes ago on your website. But otherwise, I will be available to answer any questions that you may have. Thank you.
Thank you very much. Next, we have R. Brian Black, Civil Beat Law Center.
Good afternoon, Chair, Vice Chair, members of the committee. Just a few comments. So if a government agency wants to delay disclosure of information, regardless of the merit of its decision or its position under the public records law, that agency can delay public access for years. If a requester goes to OIP, it goes to the end of a backlog list that's almost 2 years long. If they file a lawsuit, normal judicial procedures do not require the agency to move the case forward. Now, that's not what the 1988 legislature intended when it passed the UIPA. The UIPA was intended to be a system for timely and expedited disclosure of information. And this bill does three things that brings it closer to its the UIPA closer to its original intent. One, it requires the agency to move for summary judgment. The agency has all the information and they have the burden of proof. So it's critical that they step forward first to justify why it is that they're withholding access. Two, it discourages agency appeals from a circuit court decision requiring disclosure. The palpably erroneous standard of review is the same standard that's used for agency appeals from an OIP decision requiring disclosure. It's also a clearly defined standard of review that's used in other cases and is well established in the case law. These cases typically are straightforward issues of law. Judges can decide those issues of law just as well as OIP. And three, it limits the use of orders staying disclosure of records if the agency does decide to appeal. If the Hawaii Supreme Court agrees that there's merit to the agency's appeal, disclosure would remain stayed, but otherwise there would be immediate disclosure. Now, the objections stated by government agencies only reinforce the fact that they want to perpetuate a system that permits the agencies to indefinitely delay disclosure of public records, contrary to the law's original intent. People of Hawaii deserve a public records law that provides for timely disclosure of records, not access years after a request is made. I'm happy to answer questions.
Thank you very much. That's all the testifiers we have scheduled. There is the Attorney General has submitted testimony in opposition, and the League of Women Voters has submitted testimony in support. Members, any questions for testifiers? Representative Matayoshi.
Yeah, this question is for OIP or Mr. Black. That's an interesting point about the standard of review, the palpably erroneous standard being an appellate standard. I'm wondering, does the circuit court exercise the standard of review for other agency judgments or otherwise? I'm a little concerned that the circuit court just may not be equipped to handle the standard of review, and maybe we should just let them do it de novo.
So I'll take an initial stab at that. So the circuit courts, there's two different things. One, if there's an appeal of an OIP decision, the law already is, and this doesn't change, the law already is that the circuit court applies a palpably erroneous standard for decisions that OIP makes requiring disclosure. If OIP makes a decision that upholds the withholding of records, then it would be de novo review in the circuit court. So there are two standards as it applies to OIP decisions. And what this law would do, what this amendment would do, is mirror that for purposes of when the circuit court makes a decision. If it requires, if the circuit court requires disclosure, then the appellate courts would apply palpably erroneous review. And if a circuit court withholds the information, it would be de novo review on appeal.
Cheryl, is that what
I don't read the language of the bill that way. What it specifically says is either party may appeal the decision of the circuit court. They're not talking OIP decision. It says either party may appeal the decision of the circuit court. An appellate court meaning the ICA or Supreme Court, shall uphold the circuit court's decision to compel disclosure unless that decision was palpably erroneous. So it's telling the appellate court, this is the standard of review that you're looking at when you're upholding the circuit court's opinion. It's not talking about OIP's decision, and OIP's decision is not being changed in this bill. But my concern is when you tell the appellate court that they have to use this high standard of review that's been reserved for OIP's decisions now to look at the circuit court decisions, over time, they're going to say, no, maybe not. Maybe it doesn't mean what it used to mean. And maybe we should water it down, because why should we be bound by whatever the lower court has to say on this issue? You know, the lower court is supposed to be applying the palpably erroneous standard of review to OIP's decision, but we're not. We shouldn't be applying that same high standard of review to the circuit court's decision. We should be looking at the circuit court's decision on our own. We're not bound by what the circuit court has to say. After all, they're not like OIP. They don't have, the day-to-day expertise in administering this law. They might not even have any law clerks to help them. They're just swamped with all the other cases that they have to decide and roll on. And they might have got this wrong. Why should we be held to such a high standard of review when we're looking at whether or not they did it right? So actually, I disagree with how Brian has characterized the effect of this standard of review. I look at it as saying this only applies to the circuit court decisions. And he should be agreeing with me. Why would you want the circuit court decision to have such a high standard of review on appellate review? We're not talking about.
I think I might have been mistaken on the standards of review being applied at each level. I am a little concerned though about the motion for summary judgment in the 30 days. I did raise that issue a little bit earlier. That does seem like a pretty short turnaround if it's just one MSJ, then that's one thing. But if you're talking about multiple that might be hitting at the same time, that is going to be very taxing on resources. Do you have any thoughts on that, Mr. Black?
I believe the law does provide for the ability to get an extension from the judge. So if the 30 days is a problem, then it provides that the court may extend the 30-day deadline if it's in the interest of justice. So I would think that if whether it's the Attorney General's office or the Department of Corporation Counsel was swamped for whatever reason, they could just request an extension.
Yeah, I just have a feeling that's going to happen often. But thank you for answering our questions. Appreciate it.
Okay, members, any other questions? Okay, seeing none, we will move on. House Bill 784 related to trespass. Max Otani, PSD.
Hi, good afternoon, Chair, Vice Chair, committee members. We submitted a short statement in with comments and basically in support of this bill. Thank you.
Okay. Thank you. That members, that's all the testimony we have on this matter. Any questions? Okay, seeing none. Thank you, Mr. Otani. House Bill 629 relating to law enforcement. We have first Jason Redula, DLNR.
Good afternoon, Chair and members of the committee. Jason Redula, DLNR's Enforcement Chief, on behalf of DLNR. We'll stand on our written testimony, respectfully opposing this measure. Thank you.
Thank you very much. Next, Max Otani, PSD.
Hi, good afternoon again, Chair, committee members. Max Othani, Director, Department of Public Safety. We submitted testimony on comments. Presently, we're in collaboration with the Attorney General's office, and we like the concept of this bill, and we're looking forward to working with the Attorney General to see how we can, actually get this bill into, I guess, kind of coordinate with them to make this thing work. I'll be available for any questions.
Okay, thank you very much. Next, Michelle Agsada, Department of the Attorney General. Okay, I guess they didn't make it on. We do have several other organizations and individuals in support. Members, any questions on this bill? Okay, seeing none, we will move on.
It went down. Yeah, I don't know what happened. All I have on my screen is Max Otani's name and some printing on the bottom. And it said they want you to unmute, but I don't know what to do. No, mine isn't. What do you mean? How do I do refresh? What do you mean refresh? Where is a refresh? Hello? I don't understand.
Okay, reconvening the hearing. Elizabeth, are you able to,
I think I am. I apologize. My screen just went completely blank and I don't know what happened. I apologize completely. Because the judiciary stands on a written testimony, but if there are any questions, I can answer questions. I certainly apologize.
okay, members, any questions on this measure relating to the Court of Appeals? Okay, seeing none, thank you very much, Elizabeth.
Okay, I'm sorry. I apologize again. Thank you.
Okay. Okay, House Bill 776 related to the issuance of special purpose revenue bonds. Bob Hall, Pueo Development.
Hello, Chairman and Vice Chairman and members of the committee. I stand in support of my written testimony and will be available for any questions.
Okay, thank you very much. Okay, we've have comments from Director Hirai, Budget and Finance, and supporting testimony from several individuals and organizations. Members, any questions? Representative Ward.
Thank you, Chair. Mr. Paul, could you give us a thumbnail sketch of the Pueo Development Company, when it was founded and what you guys have done, et cetera?
Thank you. Pueo Development was actually formed at the beginning of last year, 2020, when we first introduced this special purpose revenue bond. It was submitted to the last year's legislature, and it did receive subject matter and money community support. However, because of the legislation, the bill was stalled. The organization itself, while formed in 2020, it has been working with the Waiahole Hawaiian Homesteaders Associations since 2010 and has been a part of all of their community development, their community securing non-DHHL financing to help develop their economic center, which is their community park. And they've managed to construct and leverage private resources, to have a very viable community center in the middle of Waiahole. That has served as the impetus for the community to try to see if they can do a larger scale of development, and through development create economic opportunities, AKA work possibilities for those residing in Waiahole. We realize that this measure still has to receive final approval through Budget and Finance, should it be successful in passage, and that none of the monies come out of the state, and it's totally leveraged with private equity. And we're prepared to try to see if that occurs.
We certainly need more Hawaiian home housing. You're proposing how many houses if your project goes through? For, is it 80 or 80? How many million is the purpose revenue bond for?
The request is for 80 million. There's no number of units to be developed yet. The land in its current state is a DHHL, it's raw land. The Waiahole Homestead Organization received approval from the Hawaiian Homes Commission last year, or I take that back in 2019, for a right of entry to approximately 150 acres adjoining the Waiahole community. And they were given that approval after a series of homestead and beneficiary consultation. An initiative was started back in 2018. So the right of entry given enables Waiahole, along with Pueo, to conduct due diligence to determine, what's capable of being built and how to finance this outside of government financing.
And when do you expect that Budget and Finance will finish their vetting? Did they give a timeline?
Well, if we're successful in getting the bill considered, it'll hopefully move out of session this year. And then it's up to Budget and Finance when they'll take the review. And at that concurrently, Pueo Development is working with Waiahuli, developing private partnerships, developing financial schemes, pretty much putting a plan all together to try to see what can be done in developing affordable housing, primarily for the Native Hawaiians.
Thank you. Thank you, Chair.
Okay, thank you very much. Representative Lopresti, do you have a question?
Yes, thank you, Chair. Hi, you certainly have the support of our Maui delegation. It seems they co-signed, and I want to help support what our Maui delegation needs on their island. I just had a question about defining low and was it low or moderate income, because it's not defined, and I'd always want to know how people are defining that, especially when it involves government money.
Thank you. The language in the legislation is pretty much verbatim from Chapter 39A. And I'm not going to try to attempt what low income and moderate income as far as dollars mean. That keeps changing. And it's always a number that everybody tries to achieve and chase. But because the land is on Hawaiian homelands, because this is an initiative to develop homestead housing, the cost of the affordable homes varies because of the land tenure. Hawaiian homes cannot, the land is still in lease. So the ultimate cost passed on to the homeowner is not the full market cost that most people receive. And again, this initiative is driven by the fact that the Homestead Organization over the last 10 years has worked to get grants, GIAs, a lot of GIAs from the legislature to build, community commercial kitchen, a community amphitheater, different community facilities. And they were able to leverage their activity, their resources within the community, all the plumbers, electricians, whoever to come in, do volunteer, to take $1 million project and turn that into almost a $1.5, $1.7 million value. So in essence, and
Thanks. I think you answered it, and I'll have to look at that section as well. And I just
thank you, Representative.
know what your definition was. Thank you.
Thank you.
Okay, Representative Nakamura.
Hey, hi, Bob. Long time no see.
Aloha.
I just wanted to ask you a question. Is this the first time SPURB is being used to do a land on DHHL lands?
As far as I know, yes. I haven't, come across, other than the normal, tax credit ventures that some of the developers do. Yes.
Thank you. I'm glad you're approaching it. Thank you.
Thank you. Good to see you.
Members, any other questions? Okay, seeing none, adjourn for, or we will recess for decision making. Members, decision-making, reconvening on decision-making for our list of judiciary and Hawaiian Affairs agenda. House Bill 740 relating to voting. Based on comments provided, the chair has a number of recommended amendments on page 4, line 11. Will indicate images shall be and delete directly, accessible, and provided electronically. So it's not directly accessible, but it will be provided electronically. Section 4, beginning on page 12, the bill will be changed. Instead of adding that section to 286-109, you add it to section 286-111 and add the amended language. And application for the driver's license shall include the affidavit and voter registration application required under section 11-blank. And again, on section 5, beginning on page 16, we change the section from 286-301 to section 286-303. And then that will read, an application for the identification card from the examiner of drivers shall include the affidavit voter registration application required under section 11-blank. The intent of this bill, I believe, is for the voter registration to be part of the application for provisional licenses as well as instructional permits, in addition to the driver's license. And so I would like clarifying language indicating that be amended throughout the bill. And I also propose other technical amendments needed for clarity, consistency, and style. If there's any questions? Oh. Yeah, I am sorry. And members, there is one additional change. One additional change on lines of 15 and 16. Changing the chief elections officer and replace that with the director of transportation. Okay, so members, any questions? Seeing none, Vice Chair, House Draft 1.
Our chair's recommendation is to pass HB 740 with amendments. Chair and Vice Chair vote aye. Representative Ichiyama?
Aye.
Representative Kobayashi?
Aye.
Representative Lopresti?
Aye.
Representative Lowen?
Aye.
Representative McKelvey?
Aye.
Representative Nakamura?
Aye.
Representative Takumi?
Aye.
Representative Todd?
Aye.
Representative Tokioka? Excused. Representative Ward?
Aye.
Chair, your recommendation is adopted.
Okay, thank you. Members, on House Bill 73 relating to emergency workers, Chair's recommendation is to pass this, including the amendments proposed by Department of Health. Are there any questions or comments? Seeing none, Vice Chair, House Draft 1.
Chair's recommendation is to pass HB 73 with amendments noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Thank you very much. House Bill 652, relating to exemptions from jury duty. Chair's recommendation is that we pass this as is. Members, any questions? Representative Ward.
Pandemic, and I know this thing is important, but wouldn't it be better if it had a sunset so we don't freak out like this is going to be forever and ever? Because this is a temporary measure, but it makes it sound like it's forever and ever. A sunset would be something to consider. That's just a comment, because I hate to think people freak out on something and think it's a permanent freak out.
Okay, thank you, Representative Ward. We'll include that discussion for the next committee.
Thank you.
In the committee report. Members, any other questions or comments? Representative McKelvey.
Oh, thank you. I'll be going reservations, Chair. I just think that we shouldn't be creating more exemptions from jury duty, but support the underlying bill for now. Thanks.
Okay, thank you very much. Any other questions or comments?
I guess I have one. Chair.
Yes. Oh, Representative Lopresti.
Thank you. If we're adding comments to the committee report, I think this is a good idea because we can't plan for emergencies. And if we have emergency workers serving in jury duty and a real missile scare happens, for example, that's why I like this bill, because we can't plan for unforeseen emergencies. So thanks.
Okay, thank you very much. Members, any other discussion? Seeing none, we'll move forward on this as is. Vice Chair.
Chair's recommendation is to pass HB 652 as is, noting the previously excused members and Representative McKelvey voting with reservations. Any other reservations? Any noes? Chair, your recommendation is adopted.
Thank you. House Bill 340, proposing amendment to the Constitution of the United States of the State of Hawaii, requiring the Judicial Selection Committee to be guided by principles of merit in the selection of judicial nominees and the retention of judges and justices. Chair's recommendation is remove this out as is. Members, any questions or comments?
Chair, may I make a comment?
Representative Ward.
I like it, but the wording to me could be better. For example, add merit to the existing qualifications, not the way it reads now, because it looks like we're doing it based on political or otherwise lack of qualification. This is the way the guy in the street's going to look at it. I think it's embarrassing to the judiciary the way it's worded, and why it's needed. I didn't hear from, I think, Representative Nadine's comment that, hey, the Judiciary Selection Committee's already got it covered. So what problem we are solving is rather moot, but the way the wording is, merit is there. And if it says add merit, I would agree with it, but I think I'm going to be no until it gets to be better and not embarrassing as the way it is right now. Thank you.
Okay, thank you. Members, any other questions or comments? Seeing none, Vice Chair as is.
Chair's recommendation is to pass HB 340 as is, noting the previously excused members and the no vote from Representative Ward. Are there any with reservations? Any noes? Chair, your recommendation is adopted.
Thank you very much. Okay, next, House Bill 631 relating to financial hardships. Chair's recommendation is that we pass this out as is. Members, any questions or comments? Seeing none, Vice Chair as is.
The Chair's recommendation is to pass HB 631 as is, noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Thank you very much. House Bill 783. Members, on this, we did not have any testimony in support, so Chair will recommend deferring this measure. Next, House Bill 347 relating to judicial enforcement of the Uniform Information Practices. Chair is going to recommend deferring this matter in light of the issues and concerns brought up by the various agencies. HB 784 relating to trespass. On this one, the chair's recommendation is pass as is. Members, any questions? Seeing none, Vice Chair, as is.
Chair's recommendation is to pass HB 784 as is, noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Thank you very much. House Bill 629 relating to law enforcement. Members, as you look through the testimony, it is there is support for this idea, but there seems to be concerns about its implementation at this time. So what I'm going to recommend to the maker is that perhaps a resolution to study this further and get together a working group to figure out this transition and maybe consider for next year. So at this point, we will defer this matter.
Well said, Chair.
House Bill 336 relating to courts of appeal. We will defer this bill as well. House Bill 776 relating to issues of special purpose revenue bonds to assist Puyo development. Chair's recommendations that we pass this on as is, and I think there is needs for amendments, but we can leave that for finance to deal with. If there's any questions or comments? Seeing none, Vice Chair, as is.
The Chair's recommendation is to pass HB 776 as is, noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you very much, members. We are adjourned.